Um, Thank you all for having me here this afternoon. And Michaela is going to share my screen for me. But I'll go ahead and get started while we're working on that. So as all of you know, those of us who work in healthcare, caring for people is rarely a simple, straightforward task. Needs differ, values differ, life experiences differ, and the choices that we make differ as well. Today, we are going to be touching on the very surface of how law and ethics factor into what we do. We will be looking at our residents' abilities to make decisions and give permission. Okay, let's see. Use my keyboard. Is it going? There we go. Okay. Now I have to. Uh-oh. Sorry, difficulty on my end. There we go. Okay, my goal is to introduce you to the importance of determining someone's ability to make an informed choice about their health and well-being, and to understand some of the legal protections in place for those who cannot make those decisions for themselves. Seems like there's a big lag. There we go. In caring for our elders, we are often faced with challenges that can lead to conflict. It is up to the healthcare team to identify the source of conflict and work through it. So before we get started, I would like to challenge all of you to think about your own values and how you might be influencing a situation when you are working with one of your residents. Are you keeping their values and goals at the center of your care? If you aren't able to recognize what is important to you, then how will you be able to separate that from what is important to your resident? So healthcare ethics starts with knowing what's important to you. Uh-oh, come on. There we go. Here are a few examples of some core values. We've all seen them as part of a business's mission and vision statement, but we can apply them to ourselves too. So after our talk today, I want you to take a few moments to identify 3 core values within yourself, things that when challenged or compromised make you feel yucky inside. These are boundaries that we don't want to have crossed, and so they're important to know. There we go. In American culture, autonomy is the preeminent guiding principle. It is the state of being governed, having the choice of being self-governed, having the choice to make our independent decisions without external assistance or restraint. We often equate it with liberty and freedom. And here we have our gentleman in his powered wheelchair going off by himself. And I'm looking at this going, what if he goes over the edge, right? Mm-hmm. Paternalism is the principle that competes with autonomy. It is when someone in a position of authority, like myself, acts in a person's best interest, but without their consent. So I'm out there, Mr. Jones, turn your wheelchair around. We're going back inside where it's safe and you won't tip over the edge of that levee. I'm trying to protect him. In Hawaii being the mixed population we are more likely to encounter additional culturally influenced values. For example, in many Asian cultures, self-determination cannot be an individual thing, but rather it's a family matter. Decisions get made based on the family's position and needs. And often the patient or the resident themselves it doesn't have a say in what happens because the family is who are deciding what needs to happen. The center of each person's life is not themselves, but the family. A decision must be made within the context of this larger self rather than the individual smaller self. And we are advancing spontaneously. Okay. So let's look at an example of the decision-making process. Let's say we offer the average adult this delicious, healthy broccoli and a mouth-watering frosted donut. That person is likely to go through a decision-making process in their heads before choosing which one to eat. They're going to ask themselves these questions and struggle internally about whether they want to eat the healthy thing that they know is good for them, will fill them up, and they'll feel good afterwards. Or do they want that yummy goodness of the donut? And yeah, well, I'll work out a little extra tomorrow so I can have it, or maybe I'll eat both. So they also know that it's not necessarily an either or decision, that when the choice is made, they can choose none, they can choose one or the other, or they can choose both. And when they do make that choice, it is with the knowledge and acceptance of the risks and benefits. There we go. Okay. So what this example illustrates is that each specific activity that involves a decision requires a different level of decision-making ability. If you had offered the broccoli and the donut to your resident with dysphagia, would he have been able to make that choice? No, it might have been a little bit more dangerous for him because he doesn't know that he's not able to swallow that, and it puts him at risk of choking on it. But if you had offered him pureed banana or chocolate pudding, he would be able to express a reasonable decision from the safe options that you provided to him. So in healthcare and legal realms, we take this same concept of providing choices and obtaining consent to a higher level. There's no single conclusive test to determine someone's ability to make a safe decision for themselves. We do have to do a little bit of background research and some testing in order to figure out whether someone is able to make a decision. Capacity is not a light bulb. It's not just on or off. There we go. So what are the essential elements of capacity, or the ability to make decisions for oneself? We have the ability to receive and understand the information that we give them, enough memory and reasoning to weigh and balance the risks versus the consequences, to be able to give their decision back to us, and then have that decision be stable over time. So they need to be able to take in, they need to be able to process, they need to be able to put back out, and they need to be consistent. So when we are asking someone to give us their consent, we are asking for them to give us permission for something to happen. In order for that consent to be lawful, the person giving it must have capacity. So they have to be able to take in, process, spit out, and be consistent with their choice and reasoning over time. In everyday things, such as completing a permission form for school, we know that children, because of their young age, don't have the capacity to make their own decisions. And a parent is required to complete the forms for them. It's just understood. Children don't have capacity, parents fill out the forms. But when we're dealing with adults, capacity is often taken for granted. We just assume when we look at an adult who appears to be completely normally functioning, that they have the capacity to make decisions for themselves. Therefore, it's on us as their caregivers and their healthcare providers to recognize when someone might not have full capacity anymore. For their safety and well-being, we need someone else to step in and speak for them. Okay, so how do we figure out if someone has the ability to give permission? First, they have to be able to take in the information. We've discussed this already. They need to be able to hear what we have to say. So let's go back to our broccoli and donut example. Let's presume it's a complex decision. So it's more than just, am I going to eat a vegetable or am I going to eat dessert? Let's say it's, a life-altering decision they have to make. And I'm going to go through those lists of risks, benefits, and alternatives with them that we had on that background slide. They need to be able to hear all of that. They need to understand that they have the choice of one, the other, both, or neither, and what they can expect from each of those choices. Can the patient focus long enough to hear everything that I have to say, or are they tuning out before we get to the end of that? If they can't remain focused long enough, then they may be that may be the first sign that they don't have capacity. Next, they have to be able to hold that information in their head long enough to really think about, okay, the donut might give me a tummy ache, but the broccoli is going to give me gas. Same. And be able to weigh those decisions against each other. And then they need to be able to communicate the decision. It doesn't have to be, I choose the donut. It can be something as simple as pointing to the donut, that, that's what they want, or pushing the food away would also indicate that they have made a decision. They don't want either of those, or they grab both of them and take them in. So they've made a choice. And obviously with food, it's a one-time decision. It's not going to be necessarily stable over time. But you could also ask them, are you sure? If you're not sure, they understand. You could ask them, are you sure you want the donut? It might give you a tummy ache. And they can nod, yes, I still want the donut. And then that would be a stable choice over time. All right. Lastly, consent must be given voluntarily. So it cannot be under duress. We cannot deceive a client or a patient or a resident. We cannot coerce them, and we cannot abandon them because we don't agree with the decisions that they've made. So one more time, back to our broccoli and donut example, our resident chooses the donut. And we go, well, okay, you chose the donut, but I'm going to make you walk an extra 15 minutes tomorrow because of that. So then they put the donut back. So now they're choosing not to eat the donut because you have threatened them with extra exercise. Now, your intention is good. You don't want them to gain weight. You want them to exercise. But the way you approached their choice to have the donut with a threat of something that they don't want to do is a form of coercion. So that's a very simple example, but it happens quite frequently. Okay, so now we have a sense that maybe our patient does not have capacity to make safe decisions for themselves. So when do we know for sure that we need to head to the doctor and look at getting a letter of capacity so that we can have someone stand in and help make safe decisions for this patient. So definitely in the case of dementia, brain injuries, so traumatic brain injuries, subdural hematomas, car accidents, things like that. And sometimes in cases of mental illness, you know, having a severe depression, someone may not be making safe choices for themselves, and we would want someone to stand in for them. What will the doctor need to know in order to write that letter of capacity? They're going to need the patient's past medical history, so that's pretty straightforward. What are their medications? How long have there been concerns? So if it's something that's brand new, that's only been there for a couple of weeks, maybe they're acutely ill and we need to be looking for something that we can fix. If it's been going on for a year or two, then maybe it is dementia that hasn't been recognized yet. What is being noticed that raises concerns? Is it a change in their appetite? Is it using their hairbrush inappropriately, trying to brush their teeth with their hairbrush? What sorts of behaviors or activities or oversights are you noticing? Have there been any recent changes to their health or medication? Have they been hospitalized? Have they had pneumonia? Is there anything new or different that's been going on? Or any major life events that have happened recently? Was there a death in the family? Did the patient have to sell their home? Anything like that can change someone's perspective and ability to speak for themselves. And then two very important questions that the doctor will need to know: is the patient at risk for immediate harm to themselves? Will they, is their home in such a state that if they go home unsupervised, they'll fall and they could get injured, or they have no electricity or running water? And then the second question is the person being harmed, being harmed or at risk for being harmed from someone else, such as verbal abuse, physical abuse, sexual abuse, or financial abuse? If yes to either of the above, then we need to consider involving adult protective services. So just very briefly, when do we need to involve APS or adult protective services? If someone we care for meets the criteria for being vulnerable, and these are the criteria here: they must be 18 years and older and have either a mental, developmental, or physical impairment, and they are unable to either make or communicate responsible decisions, so they can't give us their choices back. They have no way of communicating their choices. They can't manage their own affairs. They can't carry out or arrange for their activities of daily living. So this is when someone's going to end up in a care home, or they're not able to protect themselves from abuse. And financial abuse is fairly common and unseen. It's difficult to identify and detect when a family member may be controlling someone's finances. I'm sorry. Next slide. There we go. So what is Adult Protective Services? They are the agency within the Department of Human Services which receives and investigates reports of abuse. They are able to provide short-term services to protect the health, safety, and welfare of vulnerable adults. The goals of APS are the immediate safety of the patient or resident with the resources to stabilize the situation. However, they can only act with the consent of the vulnerable adult unless there is a court order that declares them to lack the capacity to make a decision for themselves. So this is where capacity comes back into play. So if someone has capacity and they just have physical limitations, and APS is called and comes knocking on their door, if that person is able to understand their options and the risks that they are under, they can say, no, I don't want your intervention. So that's where it's very important that we need to be able to distinguish between those who can and those who cannot demonstrate capacity. In working through difficult life situations with our residents, we, as their caregivers and care providers, have 3 key ethical and legal obligations to uphold. We must, whenever possible, preserve a patient's autonomy. Even when we don't agree with the patient's decision, if they retain capacity, we need to support them. Furthermore, in situations where they have lost capacity, if there is historical evidence for their choices, for the choices they would have made, we should be advocating for them. And then lastly, we must protect our vulnerable patients from abuse or self-neglect. It is often the path of least resistance to not report, but we cannot allow our own doubts or discomfort to keep us from acting. We also must advocate for safe disposition. This requires a lot of interdisciplinary support, creativity, and activation of legal and financial resources. We can neither leave a vulnerable patient in an unsafe circumstance, nor can we send them home to an unsafe circumstance, which is where so many end up in our care homes and foster homes, because that is a safe location for them. All right. So I'd like to illustrate this concept with a couple of examples. So this is Mr. and Mrs. Huang. Mr. Huang has early Alzheimer's, and they live alone in their home where they have lived for 50 years. Their only living child is across the country and cannot travel. They look clean, well-dressed, well-nourished. They must be fine, right? So we have a couple of considerations. Is the patient in a safe living environment? So on entering their home after a recent hospitalization, the home PT/OT noticed that the wife is a little bit of a hoarder. There are piles and boxes encroaching on every surface except the sofa and the bed. With his physical limitations, Mr. Huang is not able to move around the home safely. He uses the piles for support instead of the walker he was given when going from room to room. Is there electricity, functioning plumbing, and sufficient cleanliness? Yeah, Mrs. Huang keeps things hygienic, but we learn that their refrigerator is broken and she's been using a wine fridge for storing food. Does the patient have capacity to decide his living arrangements? And if not, is the wife making the best decisions for him? Is it possible that she herself has impairments that have not been identified? Is the supervision she is providing adequate? We learn that she goes down the street to a quilting club twice a week for 4 hours at a time. She tells us that once on arriving home, she found her husband arranging his medications, and she wasn't sure if he had taken extra doses or not. So what are the resources available to help Mr. and Mrs. Huang? Can we mobilize family, their child on the mainland? Are we able to hire private individuals to come in and help them clean up and take care of Mr. Huang's medications? Are there community resources that can help improve their situation? And at what point, if any, should a report be made to Adult Protective Services? And on what grounds would we base that call? So I want you to think about those questions. So we come to find out, oops, that Mr. Huang has an advance directive. And their child on the mainland does have these power of attorney documents for both of her parents, for healthcare and for finances. So they are willing, their child is willing to help us assist in setting up support so that their parents can stay in their home. For older adults living alone, the power of attorney grants the power of attorney document grants the person named the legal rights and powers to make medical and financial decisions for them. Even when the power of attorney is immediately effective, the person generally does not intend for it to be used immediately unless he or she comes incapacitated. So that was the case for Mr. and Mrs. Huang. So their child was able to step in and help take care of them because they had the resources and this documentation done ahead of time. So when we have a single person living alone, things can get a little trickier. So this is Mr. Gonsalves. He has been widowed for 20 years. He has no children of his own, and his wife's children never got along with him. He is a retired carpenter and still likes to work wood in his garage. He stopped driving when he totaled his car on the neighbor's mailbox last year, and that neighbor now brings him to his doctor visits. We have the same considerations that we had for Mr. and Mrs. Huang. Is the patient living in a safe environment? Probably not. The neighbor expresses concerns because he no longer appears to be grooming himself. And while the neighbor has never been inside the home or workshop, there have been growing piles of scraps of wood appearing in the front yard. Mr. Gonsalves has been yelling at neighborhood kids for leaving the mess there, but the neighbor actually hears Mr. Gonsalves out walking around the yard all hours of the night and believes that Mr. Gonsalves is the one putting the wood there and just has forgotten that he's done that. With any physical limitations, is he able to move around the home? He doesn't appear to have any physical limitations, and we don't have any known history of falls. However, being out at night in the dark with piles of wood around the yard does pose a pretty significant risk. Is there electricity, functioning plumbing, and sufficient cleanliness? Other than electricity, we don't know. No one has been inside the home recently. And does the patient have capacity to decide his living arrangements? And if not, who can make decisions for him? Is his supervision adequate? As a provider, I would say probably not. And while the neighbor is concerned enough to bring him to the doctor, he has not accepted a caregiver role. So what are the resources available to help Mr. Gonsalves? Can we mobilize family? We don't know of any. Can we obtain private hire services? He maybe doesn't have the financial resources. Are there community resources to help him? And at what point, if any, should APS or Adult Protective Services be contacted? So this is a case of an unbefriended elder. So this is an older adult who lacks capacity to make decisions and who has not completed any legal documents, such as an advance directive, power of attorney, living trust, etc. So they don't have any documents that can guide decisions and have not designated a legal authorized decision maker. It would have been wonderful if we had recognized that he was an adult orphan before his decision-making capacity was compromised. An adult orphan is an older adult who still has their decision-making capacity, but are at risk of becoming unbefriended due to lack of completed legal documents. So we want to try to identify people who are at risk should they lose their capacity later on. You might also hear these individuals called unrepresented and isolated. So what solution do we have for Mr. Gonzalez? Most likely we would end up pursuing guardianship for him. Okay. So guardianship is a legal relationship. So this is not necessarily someone who knows him or who volunteers to make decisions for him. There are organizations that take on the responsibility of managing patients' care and finances for them, and that right is given to them by the courts. It's for someone who is no longer able to take care of their own affairs and who cannot receive and evaluate healthcare information, make or communicate decisions on their own. Generally, guardianship is sought after someone has lost capacity to designate an agent or when there is no one willing to take on the responsibilities. So we asked Mr. Gonzalez's neighbor, would you be willing to make decisions for your neighbor? And he was not comfortable taking on that role. Guardianship involves a profound loss of freedom. Often, especially in cases of a public guardian, the person making decisions does not have a historical relationship with their ward, which makes it difficult for them to apply that person's personal values and preferences to making their decisions. Furthermore, designating a guardian is a lengthy legal process that can result in delays in care or disposition. Guardianship should be imposed only when less restrictive alternatives have been explored and proven to be ineffective. So as you can see, there is a lot of overlap between healthcare and legal terminology. And I'd like to bring us back to the healthcare setting. When we have an incapacitated patient, so someone who does not have the ability to make complex medical decisions for themselves, who are the people that we need to be looking for to help them make that decision or make decisions? So in order of priority for decision making, is there a court-appointed guardian? If the person we're interacting with already has a court-appointed guardian, then we're done. The guardian is the person who makes the decisions for them, not another family member, not themselves, not the doctor. The court-appointed guardian is the legal representative, and the decisions that they make are the decisions we follow. If we do not have a court-appointed guardian, is there a valid health care directive? So that care directive needs to be signed by the patient, dated, and it needs to be notarized or witnessed by two people who are not related to the patient are not healthcare workers and do not stand to inherit anything from the person. So if we have a valid advance directive that designates the healthcare agent, then that is the person that would make decisions for us, not the wife, not the daughter, but the person who's named on that document. If that person abdicates or refuses that responsibility, then we can go to the second person listed. If not, then we need to move on down the chain. So third would be a patient designated surrogate. So this is a person that the patient can talk to us and we ask them, who would you like to make decisions for you? You know, if you cannot tell me what you want done, who do you want to make those decisions? The patient tells us, I want it to be my daughter, Emily Wilkinson. Then we, the doctor or the care provider, writes that in the patient's medical record. And then that person can become the decision maker. If we don't have the ability to ask the patient, then the burden is on the healthcare team, the hospital, the social worker, the doctors, to gather together a pool of interested parties. And this can be, in the state of Hawaii, this can be anyone that has a relationship with this patient. It can be the mailman if they feel that they have an interest in a relationship with this person. And out of that group of people, they together choose one person to speak on the patient's behalf. So as you can see, there's quite a few levels that we go through. Let's say we get to that bottom there. I should have put another arrow that kind of leads back up to the point, the court appointed guardian, that if we don't have an advanced care directive, we don't have a designated surrogate, we don't have an appointed surrogate, then we go back to the guardianship application process. All right. So that was a lot of information that I've thrown at you about capacity, consent, and who can speak for the patient when they have lost their capacity to consent. Here are a few resources for you. So Catholic Charities Hawaii, they have many community resources. Elderly Affairs is the state of Hawaii resource. You'll find information on adult protective services there. And then the Caregiver Foundation is, they are an organization that represents patients as public guardian. So you can learn lots of information about guardianship from that website.
Do you need to go there? I close it. Yeah, just to read. Huh?
Okay. And thank you very much for having me talk, and I would like to open up the floor to questions.
Thank you, Dr. Christensen, for explaining such a difficult concept so beautifully. And thank you for teaching us about when to refer to APS and giving us these examples of your patients. I would like to open it up to our care home operators and foster home operators. Do you have any stories to share? Getting a letter from the doctor for capacity or calling APS? Any story that you would like to share with us?
This is Jamel Duldulao, the long-term care ombudsman. Thank you, Dr. Christensen, for that presentation today. However, there's still some, of course, gaps here that I'm aware of. I was definitely called by a foster home operator that is currently still does have the resident for 10 years, also has a case management agency on board for 10 years. Of course, initially this resident, again, lived by themselves, moved in, no longer has family, no friends. Of course, initially had capacity, was alert and oriented, but never made the decision to have a healthcare power of attorney drafted. Or so currently and presently, this resident no longer has capacity. So I know they've been working with the case management agency. At one point, the case management agency uh, utilized their social worker and attempted to convince the caregiver or foster home operator to try to be the surrogate. Of course, this is a conflict of interest, both for foster homes as well as care homes or any long-term care facilities. So at this point, they're pretty much stuck. Of course, it comes down to the cost of applying for guardianship. I'm not sure if capacity has been initiated from the doctor, because that's something that I had recommended. Let's have the doctor assess the resident and see whether or not this resident has capacity. I mean, the caregiver has an idea, but I go, we're not the doctors here, so let's get the professionals and let's get the case management involved as much as possible. So I don't know how else to support, this resident. We're not lawyers here, but is there anything that you can? I mean, I have other stories, but this is definitely one of those very challenging ones. The guardianship, there was a bill being proposed this year to try to enhance it and make it more up to date, but that bill did not pass. So any help will definitely on your end,
Yeah.
or anyone, is very helpful. Thank you.
So does that resident have any relations? No,
None,
none.
none that the caregiver is aware of. I mean, again, this resident was and is still with has this resident for 10 years. So
10
that's why I
years.
was kind of surprised, like, why wasn't this approach sooner than later? Both from the caregiver's perspective as well as the case management agency's perspective, because to me that kind of puts a lot of burden on the caregiver, especially if
Right,
there's a change of medications. So who has the legal right or authority to, if this resident ends up in the hospital, then who's going to have overall decision making in terms of
right.
what's needed? So
Yeah. And I presume the patient was managing the finances for the care home, that they
correct,
had
yes.
elected to go into the care home and is paying. um
Well, it's Medicaid, so
oh, it's Medicaid. Okay,
correct, yeah,
okay.
foster home.
Hmm. Now that is definitely a challenging situation, because someone does have to petition for guardianship. Um, and it is an expensive and onerous process, and just initiating can be difficult. I think working towards changing the laws is going to help ease things for a lot of people. I know it doesn't make this particular situation better. Um,
Because some of my ideas, as well as John McDermott, our state long-term care ombudsman, also, of course, they're able to keep their personal needs allowance of about $50 per month. So
mhm,
we were thinking maybe part of that, if they saved enough or had enough, that could be
mhm.
utilized for like a down payment on the guardianship process.
Actually, I think that would be a good approach if the patient can afford
Mm. As long as they don't over the
it.
$2,000
Yeah,
limit.
right, right. Because it is on his own behalf.
Correct, correct.
Yeah, that is a tough situation.
Yeah.
I'm gonna pose some questions to other resources that I know that, might be able to help us with that.
Yeah. So that's why when I've
Okay,
been visiting my long-term care facilities, especially the foster home care homes, I am checking in with them to see whether or not, their residents do have healthcare power of attorneys. Again, just don't want to be stuck in the same situation where, don't wait too long. I mean, even
right.
for us, I mean, I have one, I've created one, I did the trust and everything so that I know I'm set. So I'm setting an example, not only for myself, but also for others. So that's always the challenge is, do you have one? And I go, yes, I can say I have one. I have a healthcare power of attorney, and I have a power of
Yes,
attorney. I have a trust. I have the living will. So all of that is all set. So, and plus I got a lot of my training from Kukuo Mao, and we always said, if you're 18 and
yes,
over, you should have an advanced directive. So
yes, yes. Agreed. So prevention is the key. It doesn't fix this particular situation. So,
Yeah.
so yes, identifying those adult orphans before they become unbefriended elders.
Yeah.
Definitely. Yeah, thank
Thank
you for
you.
sharing that.
Thank you, Jamel, for setting such a good example.
Thanks.
You practice what you preach, and I thank you for your good example. We have a question in the chat, Dr. Christensen, which says, can the Office of Public Guardian assist with getting guardianship?
I do not know the answer to that, but I can find out the answer.
To my knowledge, that is where people end up. It is the destination. It is the final end of the train. So they don't typically assist with getting guardianship, though they serve, OPGs will serve as the guardian if a ward has no relatives, no friends, no one who wants to step in. But if we are looking for resources of how could we do this in a less expensive way, then we might think of reaching out to legal aid. We might think of reaching out to the University of Hawaii. They have an elder law program and an elder law clinic. And my own patients at Kokuakalihi Valley had, one of the mothers for a disabled son had obtained guardianship free of cost through the U-Help program at the law school, the elder law program. Thank you for sharing that link, Michaela, in the chat. If you want to look at their website of the law school and the elder law program, please click on this link. I would like to open up for any other, anybody else would like to share about their challenges with getting a doctor's letter or APS, any APS cases that you wish to discuss that deals with decision-making and capacity.
Well, this is Jamel again. I do have another case. Well, this one is also kind of unique and ironic. This resident is very alert and oriented and is seeking healthcare power of attorney, but he doesn't have friends, nor does he have family. I guess we just don't have a process where we can't just assign him a healthcare power of attorney. And he's been asking, so which is again, we're also stuck. You know, we've tried to connect him with his university alumni. You know, again, he has no friends, no family on the island, but we've been trying to, and he's very vocal. I mean, he's very sharp. He knows what he wants. But again, another challenge for you to hopefully help and connect us with some resources. So thank you, Dr. Christensen.
So if I understand correctly, the person is looking for a healthcare power of attorney.
Yes.
Okay, I want to share with you some stories. Please do not name your favorite doctor as your healthcare power of attorney. Please do not name your pastor if you don't have the pastor's permission, because we had a case where we were going every week to St. Francis. That time that there was a St. Francis hospital in Liliha, and the poor pastor, he had no idea that his patient had named him. She had not told him, and every week we were having meetings and meetings and meetings to discuss what would have been in her best interest, because the healthcare power of attorney works on the principle of substituted judgment. Substituted judgment means what would the patient have wanted? Not what the pastor thinks should be done, but what he thinks that the patient would have liked to happen. So an important point when you choose someone, please tell them, check with them if it's okay that you could choose their name. Another point to keep in mind is you don't want to choose the one you love the most. Oh, I love my daughter, or I love my son. you want to bear in mind who is the person who could represent you, especially in a setting of hospital, doctor setting, emergency room. Maybe you may have a child who hates hospital. They hate blood. They don't like any of these things. So if you name that person, it will be very difficult for them to serve as your healthcare power of attorney. So you got to choose wisely, and you got to make sure that this person is aware, because they are going to be your advocate. They're going to fight for you and what you want to be done when you can no longer speak for yourself or make decisions. Other stories anybody would like to share about their patients in the care homes, in the foster homes?
It looks like Melencia might have her hand raised. Did you want to say something? Melencia Marquez?
You're muted, Melencia. Maybe you can unmute and ask your question, please.
Okay, thank you very much for sharing all those about essential of law and ethics in elder care. And about guardianship, I realized that the guardian make decision for the patient, designated healthcare agent or appointed solely. Thank you. That's all.
I'm sorry,
Melencia, we couldn't hear you clearly. So is there a question? If you could repeat your question slowly and clearly, please.
I don't have question about that.
okay. Thank you. I'm glad I hope you learned something. Yeah.
Thank you. We will move on to our next slide, John. And there is a very good comment in the chat. If one becomes suddenly mentally incapacitated, physically able, ambulatory, then someone becomes their conservator or guardian. Conservator has the power to not prolong patient's life, but patient somehow communicates to life. Then there's a conflict of interest. That's right. Sometimes we may have a conflict of interest, and you might need to consult an ethics committee. That's why most hospitals, they all have an ethics committee, especially when you're concerned with conflicts of interest. Now, I would like to end with some of these things. Please share with our team the screening of your patients. It's important in your care home and foster home to just screen. Has your patient been screened for dementia, for depression, for delirium? And you may not be the one doing the screening. It could be the doctors, the case manager, the nurses. So just let us know how many have been screened in the past year. Next slide, please. To obtain a certificate, we need you to fill out the evaluations. So look at the link. Michaela has put the link for the evaluation. Everyone who wants a certificate of attendance, they must complete this form. Next slide, please. I would like to invite the Alzheimer's Association if they want to say a few words about the caregiver support group. There's some wonderful things going on.
Yes. Hi, everyone. Thank you so much. Last year, we tried the professional caregivers support group, and we didn't get a whole lot of people, but this year we're really hoping to help you guys. We are here to help you. So I went ahead and put the link in the chat where it's under TT, the green little square with TT. And that's me, Tanya Tullis. So if you want to just register and then show up May the 25th, actually not in person, but it's going to be on Zoom. So we look forward to seeing you and just being able to talk story and just take a break and just take a breather and just help each other. That's what we're here for. So looking forward to seeing everyone. Thank you.
Thank you, Alzheimer's Association. They do a lot of good for our community. We will send the eval link again. Michaela will post that again. Next slide, please. Mary Bell, if you'd like to say a few words to our foster home and care home attendees.
Hi, thank you, Dr. Christensen, for taking the time to be the speaker of the great topics today about essential of law and ethics in elder care. That's really helped us a lot in our foster home and care home, because there's a lot of who doesn't have power of attorneys, advanced health care directives, or surrogates, or even just even guardianship. Thank you for the great topic. And thank you everyone for joining us today. I hope that you learned a lot and be able to use it in our clients. Please don't forget to do your survey to get your certificates, and see you all again next month.
Mahalo, everyone.
Thank you very much,
Thank
everyone.
you.
Thank you. Mahalo nui.
Thank
Aloha.
you.
Thank you.
Thank you.